The Insolvency and Bankruptcy Code, or IBC, provides a structured framework for dealing with the insolvency of businesses in India. A key element is the Corporate Insolvency Resolution Process, often referred to as CIRP. This process aims to revive financially distressed companies, or if that's not possible, ensure an orderly exit. CIRP can be initiated when a company defaults on a debt exceeding a specified threshold. This default can be on a loan from a bank, unpaid dues to operational creditors, or even defaults on payments ordered by a court or tribunal. The IBC broadly categorizes creditors into two groups: financial creditors like banks and operational creditors like suppliers. A critical aspect of CIRP is the role of creditors. They have the power to decide the future of the struggling company. This could involve reviving the company through a restructuring plan or liquidating its assets to repay debts. The IBC emphasizes maximizing the value of assets and balancing the interests of all stakeholders involved. Arbitration is a well-established method for resolving disputes, particularly in commercial matters. An arbitral award, once made, has the force of law and is usually binding on the parties involved. But can an arbitral award, which represents a debt owed by a company, be a trigger for insolvency proceedings under the IBC? The answer is yes. The IBC recognizes an arbitral award holder as a creditor if the award obliges the debtor company to pay a sum of money. This means that if a company fails to honor its financial obligations stipulated in an arbitral award, the award holder can potentially initiate CIRP against the defaulting company. However, for an arbitral award to trigger CIRP, it must meet certain requirements. Firstly, the award should be enforceable as a decree of a court. This means all appeals or challenges against the award must be exhausted and it must have attained finality. Secondly, the debt reflected in the award must exceed the minimum threshold limit for default specified under the IBC. When dealing with domestic arbitral awards, the IBC's provisions are relatively straightforward. If a company fails to honor a domestic arbitral award that has attained finality, the award holder can approach the National Company Law Tribunal, or NCLT, to initiate CIRP. The NCLT will examine the award to ensure it meets the IBC's requirements. Several landmark judgments have clarified the position of arbitral awards under the IBC. In the case of, the Supreme Court held that an arbitral award, once enforceable, is a debt and can trigger insolvency. Similarly, the Supreme Court reiterated that the NCLT must focus on the debt and default when an application is based on an arbitral award. This means the NCLT shouldn't re-examine the merits of the dispute decided by the arbitrator. Foreign arbitral awards, while enforceable in India, require additional steps before they can trigger CIRP. Under the Arbitration and Conciliation Act of 1996, a foreign award must first be recognized and enforced by an Indian court. Once a foreign award receives recognition from an Indian court, it is considered equivalent to a decree of that court. This recognition paves the way for the award holder to approach the NCLT for initiating CIRP against the defaulting Indian company. The NCLT will then apply the same debt and default criteria as it would for a domestic award. In conclusion, an arbitral award, whether domestic or foreign, can indeed become a trigger for CIRP under the IBC. The key is to ensure the award has attained finality, is enforceable as a court decree, and reflects a debt exceeding the minimum threshold. This mechanism provides a powerful tool for creditors seeking to recover dues from companies that have failed to honor their obligations under arbitral awards.